All right, counsel, begin whenever you.
Good morning. Patrick Chidnius for the petitioner, United Property and Casualty Insurance Company. I'd like to reserve 5 minutes for rebuttal. So the procedural background that led to this petition is a little convoluted and idiosyncratic, but the question of law before the court is not. May the plaintiffs redact the header of an email upon which their expert relies as attorney-client privilege or work product. Now, this should seem a little odd to the court. It strikes me as odd because usually it's the other way around. Usually it's a party redacting the body of an email, and then in their privilege log, they disclose the sender, recipient, date, and time.
Mr. Chambers, do you agree that in this court anyway, the standard for getting a cert petition or having an order that is cert worthy based on the denial of discovery is that that denial has to eviscerate the party's claim or defense?
That's correct, Your Honor. And I'll
does not getting this discovery about these emails, about an email to an expert during a deposition, eviscerate your client's defense?
It does, Your Honor. And there are two forms of irreparable harm. But to understand that, you got to understand a little bit about the idiosyncratic nature of the expert's report, what happened at the deposition, and how the trial court ruled.
Is the expert going to testify at trial?
That's correct. This is their only causation expert. But
right. And do you have a causation expert?
Well, we do, Your Honor, but I'll go back. Their expert doesn't necessarily have to testify at trial, and that's important because the deposition could be used in lieu of live testimony.
And if assume what you seem to be trying to prove is that counsel emailed photos to the expert during the deposition.
That's part of it, Your Honor.
The expert's opinion.
That's part of it, Your Honor, but it's more fundamental and more important than that, because this expert, Mr. Rennie, he's never visited the property. He's never conducted any tests of the property, didn't send anyone to inspect the property.
Sounds like impeachment.
Well, it would matter certainly for impeachment, and I'll come back to that, because impeachment is also a basis for certiorari review if you can't establish on plenary appeal what that impeachment evidence was going to say. Now, I need to go to the core how important this is.
Okay, go ahead.
So,
I mean, you can tell I'm a little skeptical here.
Of course, Your Honor, and I want to try to remedy that. The opinion in this case is unusual. It's this photograph-only opinion. Now, Mr. Rennie shows up at his deposition, and 10 minutes before the deposition, he sends us 15 to 20 emails. Those are not at issue. During the deposition, he sends us 4 screenshots of emails. Now, those are the emails that are at issue in this proceeding. At the beginning of the deposition, we turned right to this report, his expert report, that relies on 8 attached photographs. And the curious thing about it is the only dispute in this case involves interior damage. Now, Mr. Rennie is the only causal link to the interior damage. He's the only expert they have on this. He's the only person who's going to testify at trial. In the observation section, which is at Appendix 360, he has one sentence that says, "I observed interior damage, down gradient from roof damage during the site inspection." Well, that's curious because he never inspected the property. So we asked him, what do you mean? What do you mean by the site inspection? And he says, well, I'm referring to the photographs in my report. Now, he specifically says that. So we want to clarify that. And he confirms for us that the entirety of the damages he documented are the 2 photographs attached to the report. We then went further and asked him, can you confirm those are the only photographs of interior damage you have for your opinion? And his response to that was, I need to take a minute to look. And we say, take your time. And he says, yes. Now, as I'm sure the court knows, shortly after that, the opposing counsel requested a 5-minute break. After that, Mr. Rennie comes back and says, I went back and found in my deleted box the link to other photographs, 154 new photographs he had not previously produced. Now, we proceed to try to uncover the origin of these photographs, and he sends to us an email, a screenshot of an email at 12:02 p.m. He placed this email directly at issue as the foundation for his opinion. But the only thing missing from it is at the very top, if you look at Appendix 59, in parentheses, is work product attorney-client privilege.
I'm waiting to hear how this eviscerates your defense, Mr. Children. I mean, I understand the scenario that happened.
Yeah, so the first aspect of this is that we challenged this opinion at a Daubert hearing. And at that Daubert hearing, we argued that in his initial testimony before the 5-minute break, He said that he had no idea what these pictures were. He didn't know if they were in the same room, different rooms, who took them, when they were taken. And we said that's not sufficient under Daubert. The trial court disagreed, found this methodology sufficient. Now, at trial, an expert doesn't have to lay the factual predicate for their opinion. An expert can walk into court and say what their ultimate opinion is, and it's up to the opponent to cross-examine the expert. Now, this great latitude you have to challenge an expert is the obligation of the opponent of that testimony to try to attack the discernible, factually based chain of underlying reasoning. In this case, the only underlying chain of reasoning is a set of photographs. We are entitled to know which photographs were actually part of this opinion that he disclosed months before his deposition, and which ones are not. That opinion, this causation opinion, is the core of the issue to be presented at trial. And we are entitled to question the fundamental pieces of that opinion. And without doing that, we have no defense.
And knowing, having the headers to the emails, does that how?
The header of the email will tell us if these particular photographs were received by this witness back when he formed his opinion, like he testified after the break, or whether he never saw these photographs at all when he formed his opinion in this case.
Oh, yeah, but he's not entitled to change his opinion or modify his opinion based on further information given to him?
Well, the other side of that coin is if he's allowed to just continually change his opinion, we're entitled to see the information that he's relying on. And he produced it for us.
But having these headers to these emails is critical to that inquiry.
It is, because it would impeach his.
That eviscerates your defense.
It would eviscerate our ability to challenge his opinion disclosed in his report. And now if he's going to change his opinion months after the expert disclosure deadlines, that's fine, but we're entitled to see that information he's relying on.
And how come you get a cert from this rather than correct any error that occurs on appeal from a final judgment?
Well, two pieces. Think about what happens on plenary appeal. If we go up on plenary appeal with this record, they're going to say you can't show that he didn't rely on those emails back when he formed his opinion in his report, and so we can't establish the error is harmful. I'm sure we're going to see that on plenary appeal. If we can't tell the jury, no, his opinion that he disclosed to us is not based on that 154 photographs like he testified originally, it's based on the 2.
And what difference would that make to your defense?
It would certainly allow us to call into question this foundation, again, the factually based chain of underlying reasoning supporting his opinion.
I'm not suggesting the photos are doctored.
The photographs, the additional ones?
Right.
No, I think the email.
You're not suggesting, as far as I can tell from the briefing, that they, in terms of quality of what they're showing, differs substantially from the photographs taken by your own investigation.
No. What they've altered is what he claimed to rely on in that email. When he sent us the email with the links. But I also want to point out the second piece of what I was talking about. This, like I said, this deposition could be presented at trial. When this witness takes the stand, he places his credibility in issue. Now, another piece of simply impeaching the foundation for his opinion, which again, we need to know exactly what photographs he had so we can challenge those at trial, and trial is set to occur at the end of next month. The second piece of this is when we came back from that break, his testimony on the record was, I went back and found the link in my deleted folder. Now, if he received this email sometime other than when he said back in 5 months earlier, 8 months earlier, when he formed his original opinion, that statement's not true. And if we are entitled at trial to impeach his credibility, if that statement is in fact not true, it's not true because if he received the deposition, say in the middle of the email in the middle of the deposition, he didn't go back to his deleted folder. He didn't find it in the deleted folder. He had it right in front of him. And it begs the question to me, why redact just the headers? I still can't get past that. Why would you send this to us? Their expert sent it to us, said I relied on this, but you can't see when I looked at it. Now, I don't think there's much of an argument on the essential requirements of law here. That information is not privileged. It's not subject to work product. That's exactly the information you're supposed to disclose in Florida if you want to assert privilege or you want to assert work product. It's what you would ordinarily include in a privilege law. There is no case law. We saw nothing. And there was an argument in the trial court, but the response to our petition makes no argument that this information is in fact privilege or work product.
And if I may, Mr. Chinese, can I just jump in and maybe to follow the thread of Judge Northcott? At trial, aren't you allowed to get into all of that? You could certainly impeach the witness by saying, when we took your deposition, you indicated you relied on these 2 photographs. Then we've taken a 5-minute break, and lo and behold, you now indicate that you're relying on these 150. You're still able to bring all that out for impeachment purposes to make that expert look bad or issue regarding credibility, you're not being limited by that. So which then begs the question, you're up here on cert, and on cert, there has to be a clear departure that any type of this type of information that is really critical. If you're going to be allowed to proceed with your impeachment, how can that still be cert worthy in this case?
Yes, I think the key there is that we will not be able to impeach it. The point is, after the deposition break, he came back and said, this refreshes my recollection. I did review these 154 photographs. And then he, by his own volition, sent us this email as to prove that fact, but he had omitted the header. Now, at trial, I presume, if he testifies live, consistent with this deposition, or they admit the deposition, either way, he tried to come back and say, actually, no, yes, I did review those. And here's the proof. He emailed it at 12:02. So we will not be able to impeach him because we won't be able to say, no, you didn't. That thing you're giving us as proof that you relied on these photographs, you did not have that when you rendered your opinion. You got that in the middle of your deposition. We won't be able to show you that on plenary appeal. And as I said earlier, I'm sure the argument will be the jury issued a credibility determination, and we'll be missing a critical piece of impeachment that under the rules of procedure and the rules of evidence, we are absolutely entitled to. That is.
But Mr. Childress, right off the bat in your brief, you cite Dempsey and Stewart, for the proposition, hey, you need to be able to get this stuff because it's critical to be able to cross-examine the experts on the basis for their opinion, correct?
That's correct.
Both of those decisions were on appeal from a final judgment. So I'm still having trouble, since this goes to impeachment of an expert as opposed to the core of your defense. I'm still having trouble how this gets to be a cert.
Sure. The core of the defense, again, you have to understand that this is the only evidence they have of causation and damage. It's this.
The core of your defense is that it's not that the damage. I'm restating the core of your defense is the core of your defense is not that the other side only has one kind of evidence, right? The core of your defense is that the truth is otherwise.
No, they do have one type of evidence. They have just photographs.
How does that become the core of your defense? The core of your defense has to be there's no causation. That's the defense.
Right, but they're building their causal bridge using only photographs. And so the key, the crux of our defense at trial. Now, I think that in many circumstances, I think the trial court's Daubert ruling was probably about as tenuous as it can get. This witness, as to the photographs in the report, had no idea who took them, couldn't say if they're in different rooms, didn't know when they were taken, didn't know anything about them. The trial court let that slide, and I recognize that's not up right now. But that's the world we're living in at trial. We're living in a world where this witness is going to rely only on photographs attached to the report. And by relying only on photographs, that is the only thing we can attack. We only have the ability to attack the discernible factually based chain of underlying reasoning. In this case, that is nothing more than photographs. And so which photographs they're talking about, that's the critical, that's the only way we can defend the case. So it doesn't go to the core of our case, it goes to the core of their case. It's our only ability to defend against it. Nobody else is going to get up and say, this damage was caused from the roof, this damage was caused by flood. And they're going to ask him, how do you know that? And he's going to say, I looked at photographs. Now, at a minimum, we're entitled to know what photographs. And this goes back to the point that we aren't digging through counsel's email inbox. Mr. Rennie made these immediately and critically relevant by sending them to us at 12:02, except for the header, and saying, oh, I also relied on this. We're entitled to know the details of these photographs because that's the only thing we're going to be able to challenge at trial under the existing Daubert ruling. And just as importantly, as I mentioned, if this is the case, if he really did go back and find them, well, then that would explain his confusion at the beginning of the deposition that he only relied on the 2 interior photographs. But if that is not true, if it is not true that this thing he sent us to prove he looked at 154 photographs, if he did not have that back when he issued the opinion, like he testified when he was trying to sort of recant his initial testimony, that is a critical piece of impeachment on his credibility. If he misrepresented that fact, there's no way we will be able to prove that on plenary appeal. We won't have the information. So I won't be able to tell you the impact that would have had on the jury. And we cite a couple cases in our reply for the point that this type of missing critical impeachment evidence of an expert independently warrants certiorari review. Because again, how am I going to come here on plenary appeal and tell you he misrepresented something in his deposition that we could have read to the jury, but now we can't. That is the quintessential kind of missing information that we need to be able to present to the jury at trial. And there's no other way we're going to get that. I'll touch briefly on the response, which again, it makes no effort to defend these redactions.
And before you get into that, I'll point out that you're heading into your rebuttal time. So use the time as you wish.
I'll reserve my time.
Mr. Martinez?
Mr. Martinez, you are muted, sir.
Thank you. Sorry.
Do that all the time.
May it please the court. Thank you. Members of the court, we're arguing about a ruling that the court never made. The court's ruling was that she reconsidered a previous decision to compel Grant Rennie to look for other emails that he may have had. The trial court never said the ruling was based on a finding of privilege. The order from which United UPC appeals is also silent on the reasoning. And we had given her another reason to deny it in our response because we argued Rule 1.280 does not require disclosure. That could have been the basis of her decision. But more importantly, this is a case where UPC opened coverage on a first-party insurance claim. They paid the
Before
roof.
you leave your last point, forgive me, I was too
Yeah.
muted. When you talked about the trial court's order, and looking at the order we have on appeal, the denial, and I was preparing for today, I came across an opinion from this court in Gia Coloni, authored by Judge Wallace, and it explained that there was an order that had no explanation of its decision, denying individual discovery request, and such a denial of relevant discovery is an insufficient order. Should we address the insufficiency of the order, or has that been waived because no one has really argued it?
Our position is that it's been waived. No one's argued it. Certainly the appellants.
So then I noticed that we're talking about what the court didn't do. Then if it's waived, it doesn't really matter what the court didn't do. We just follow what Judge Northcutt, right?
Yes.
The line of reasoning he was putting forward. Because I was just concerned that this order may not be sufficient.
Right. That our position that's never been argued. But insofar as the facts of this case, the insurance company opened coverage. They paid for the roof. They paid for the entire roof because it was damaged by Hurricane Irma, and it was extensive damage. And they paid under $1,000 of interior damage. And they sent 3 field adjusters out to the property, and they decided to pay those monies. And so they are claiming that the floodwaters that came into that house, which were only 2 inches of surface water, which receded after a few hours, that flood company should pay for those damages. However, the problem is that above those 2 inches and above, 2 feet, which is sort of the industry standard for what's a surface water versus what's wind damage, above 2 feet, there was a lot of damage. There's damage to drywall, which is not something that can be documented by way of a photograph. There was damage to windows. There was damage to kitchen cabinetry, damage to air conditioning units, HVAC systems. And so there was a lot of damage to this property. We don't even need to call Mr. Rennie as an expert in this case, because the fact that the insurance company opens coverage for a roof that is damaged and is allowing rainwater to enter the home during the hurricane, and there's obviously extensive damage, we wouldn't even need to call him as a causation expert. I think the jury would understand that water doesn't travel upward, it travels down. And so that rainwater that came, or those damages that are above 2 feet in that home, had to have been not from surface water, but rather from rainwater coming in through the damaged roof that the insurance company paid for. Insofar as what Rennie reviewed, he didn't just review these 154 photos that he testified during the deposition. He testifies during that same deposition that he reviewed 200 photos from a field adjuster from the insurance carrier, and that's not disputed by the appellant. And at any time, not during deposition, not in their brief before this court. He also reviewed motions for summary judgments, exhibits, hurricane data, repairs and receipts. He spoke to the Millers. He looked at photographs provided by the Millers. And I've mentioned the 200 photographs from the UPC field adjuster, but there's a number of things that he reviewed informing his opinion. And insofar as the testimony that has been attributed to Mr. Rennie, I would suggest to the court that a full reading of his deposition would really shed light on the fact that he didn't change his story. He was just very specific about the question that was being asked. And on redirect, he said, look, I have, 4 photos in my report, and I didn't just draw them. Those 4 photos came from somewhere, and they came from those 154 photos that they're now claiming that Rennie didn't have up until the time of the break of that deposition. So our position is that petitioner, they failed to show that there's been any denial that their defenses have been eviscerated in any way. They haven't demonstrated irreparable harm, that they haven't even identified a defense, let alone demonstrated how the defense is eviscerated if it is hampered in its ability to cross-examine Rennie when he received 150 of the more than 350 photographs that were taken in this case. Our position is that this petition should be denied on that basis. Certainly, they'll have a wide latitude in cross-examining Mr. Rennie. The trial court actually in its order said I'm going to grant them wide latitude to explore all of this, to cross-examine Mr. Rennie at length about it. And, we welcome that cross-examination. It sounds from his arguments this morning that he's going to have plenty to talk about and to cross-examine Mr. Rennie about, but these are issues that are not appropriate for cert review, but rather for appeal after a jury verdict. And I thank your honors for your time.
Thank you, Mr. Martinez. Mr. Chilness, you're up.
Thank you, Your Honor. I want to touch briefly on Judge Casanueva's concern about preservation. Obviously, the trial court's oral pronouncement and oral discussions during the hearings inform the final order. If you track the hearings, there were 3 pertinent hearings. You can tell that the arguments that were advanced were attorney-client work product. That's the redaction on the face of the email we need, and that is in the privilege log. And if you track those.
And I was just wondering whether there was any issue on the sufficiency of the order and whether we had to address that or not. And as pointed out, no one has raised it. So I just wanted to be clear on that it hadn't been raised, and we'd go on with what we had before us. Because if it's the form of the order that precludes review, then that would be different, I think, than what we are posited right now.
Yes, thank you, Your Honor. And I believe that the attorney-client work product was the basis for the ruling. We've addressed the other argument that counsel pointed out, 1.280. This information is certainly discoverable under the rules. We track that in our brief. But the most important point I need to get back to is why this matters, why I'm asking you to issue a decision in this case. Mr. Rennie is basing his opinion on something that's very thin. And at trial, we need to know exactly what he relied on, what he said he relied on. And the attorney-client privilege, work product doctrine, those are really important and storied doctrines. They by their almost definition, stand in the way of relevant discovery. We have yet to hear any defense of the redaction of this header as attorney-client privilege or work product. And it comes back to the fact that Mr. Rennie is the one who gave us this document. So I am relying on this, but he refuses to tell us the header of that email. When did he get it? Who sent it to him? And when? That is all something we're entitled to discover. The other side of these really powerful protections and privileges is that they should be used correctly and judiciously. At the end of the day, again, that's the most important question I have. Why redact just the headers? There's information there that is highly relevant to us. We need to know which photographs he looked at, which ones he didn't. And he said in his deposition, my memory is refreshed now that I see this. Well, we need to know what it was he saw. We need to have that ability at trial. If he doesn't testify live, nobody's going to be able to cross-examine him. They're just going to present his deposition.
Did he not in that deposition say, I saw these?
Certainly said that after the break, but before it, before that, he testified.
During the deposition, you had the opportunity to cross-examine him then.
But he contradicted himself, and we didn't know what that document said at the time. So we received it at 12:02. Well, Your Honor, we asked him, when did you get this? And he says, I don't know. I don't remember. I deleted the email. The header of that document will tell us the answer to that question. So he did not answer our question. He redacted it as attorney-client privilege work product and refused to give it to us in that deposition. So we did not have a fair opportunity to cross-examine about it. And if he doesn't show up at trial and they rely on that transcript, what are we going to do?
Well, I suppose you could read the parts where you cross-examined him on that.
But we didn't have the information. We still don't. We still don't know when those photographs were sent to him. He redacted it improperly as attorney-client privilege or work product. And if we go forward without this, we have no remedy on plenary appeal. So we're asking the court to grant us certiorari relief so we can have this information for the trial that's set next month. Again, what we're asking the court to do is to give us the information we need to impeach this opinion. This opinion is unusual. It's based just on photographs. And at that deposition, before he changed what he was testifying about, he committed unequivocally that these were all the interior photographs he had. We asked him to go back and check. He went back and checked. He testified under oath. That's all I've got. We asked before the deposition, if you sent us everything you have. Yes. So it's not that he went back and remembered. He's contradicting his sworn testimony after the deposition break. So
From heaven for you, Mr. Chidneys.
come again?
Isn't that manna from heaven for you?
Well, not at all, because we don't know if what he said later is true. We can't prove when he got these emails that this redaction stands. And the jury may well believe his story that, well, now I remember these additional emails. We are absolutely entitled under the rules of discovery and evidence to know when he got these new emails. And if he misrepresented before the break that he gave us everything he had. He may well have done that. We believe he did. We believe he sent us everything he had, and we gave him plenty of time to go back and look for more interior damage photographs. All of a sudden, he shows up after a 5-minute break with 154 new photographs, and he sends us on his own. Again, this is what it goes back to. He made this at issue. He made this extraordinarily relevant.
Photographs that he looked at that were taken by your adjusters, your investigators.
Sorry, come again?
How many photographs in total had he looked at, or did he had access to before he filed the report?
Before he filed the report, he testified that the only site inspection he performed were the 8 photographs attached to his report.
Right.
That's what he was relying on. He did not say before that break that I looked at these 154 photographs. He never said that. He said that after the break. Before the break, he said, I have 8 photographs, 2 of them.
Photographs taken by your adjusters?
The photographs that were attached to his report?
No, the photograph, had he looked at the photographs taken by your adjusters?
No, he did not testify to that until after the break. After the break, opposing counsel said, does this refresh your recollection as to whether you've seen it? And of course, he says, yes, of course, I looked at all those. He was asked, why didn't you include them? He says, I don't remember, or I included these 2 photographs because they were better. But he doesn't mention those 154 photographs ever before that break. In fact, he commits that he's given us everything he has. He's given us all the interior photographs and says only those photographs support his interior opinion. It's only after the break.
Your time is up.
Thank you for your time.
Thank you both. In order to leave the virtual courtroom, you need to click the button called Leave on your Zoom screen. And you disappear into the ether.
Thank you, Your Honors.
Thank you, Mr. Martinez. Okay, the court will be in